Mr Speaker, I commend this bill to the House.
I call Dennis O'Rourke.
Mr Speaker, the people of New Zealand need to ask themselves a very important question in relation to this bill. Are they willing to give up some important personal rights and freedoms in exchange for better law enforcement? Few would agree, I think, Mr Speaker, because the price is too high. And people don't know that it's happening. It's up to us in this House to see that it does not. New Zealand First strongly opposes the bill. It does not protect personal rights, and the benefits of better law enforcement cannot be bought at the cost of compromising important personal rights and freedoms. Parts of the bill will start New Zealand down the road to a police state, and it is no exaggeration that the bill will do that. Some accuse the previous Labour government of wanting a nanny state. Does this national government want to move from the nanny state towards a Nazi state? If government is careless about compromising personal rights and freedoms, then this House cannot be. Now, the purposes of the bill, the purposes for what it was intended are right and proper, but it goes much too far. It partially abrogates some very important personal rights and freedoms. Now, reform of search and surveillance was needed. It consolidates and improves these powers, current in 69 different acts. It does remove many inconsistencies. It codifies existing case law. It clarifies powers which are too often unclear. It provides regulation for high technology devices used in surveillance. It seeks to ensure judicial oversight where it's needed. It places issuing functions for warrants in experienced hands. It provides for public reporting of use of powers and other safeguards. But these are not enough, especially given the intrusive nature of some of the powers, scope for abuse of personal privacy, limitation on the right to silence, scope for abuse of private information, of the use of private information, accessed by a great number of state agencies, not just the police, and these can be extended further by order in council, and lack of sufficient and effective objection procedures. Now, the bill is a very large one, but there are 4 areas of particular concern. In my view, the most important of these is the provision for examination orders in a non-business context. Currently, only the Serious Fraud Office can require a person to answer questions, compulsory examination, in serious fraud cases, a business context. But apart from the Serious Fraud Office power, the law has protected the right to silence since the abuses of the Star Chamber in the 16th century. A right to force people to talk or face prosecution is a short distance from interrogation with force. Now, I want to remind the House about the origin of the right to silence, because it's an extremely important right that we must keep in mind here. Now, in the Star Chamber in the 16th century, people were forced to make an oath in which they were required to swear truthfully to answer questions put before them without knowing what they were being accused of. And this created a cruel trilemma, as it was described, and the accused were forced to choose between, on the one hand, perjury if they lied to protect themselves, or contempt of court if they refused to answer, or thirdly, if they betrayed their natural duty of self-preservation, if they were forced to speak. Now, Mr. Speaker, the rejection of the procedures of the Courts of Star Chamber eventually resulted in this right to silence principle, and that right has remained enshrined in the common law tradition inherited from England, and in the United States it is expressed in the Fifth Amendment to the Constitution. These rights evolved and operate in Anglo-American jurisprudence, one through rights expressed in an entrenched constitution the other in Acts of Parliament, which unfortunately, as in this case, can easily be changed. In Australia and New Zealand, where police officers are still required at common law to inform an arrested person that they do not have to answer questions, but that whatever they say can be used in courts and evidence, is a very important right. The right is recognised in key international human rights documents such as the International Covenant on Civil and Political Rights. The European Court of Human Rights has held that, quote, "The right to remain silent under police questioning and the privilege against self-incrimination are generally recognised international standards which lie at the heart of the notion of fair procedure." In France, the French Code of Criminal Procedure makes it compulsory that when an investigating judge hears a suspect, he must warn him that he has the right to remain silent, to make a statement or to answer questions. In the United States, the Fifth Amendment to the Constitution codifies the right to silence, and following Miranda in the state of Arizona in 1966, the Supreme Court has ruled that suspects questioned while in police custody must be told of their rights to silence, including during the execution of a search warrant. Now, Mr. Speaker, clauses 31 and 32 of the bill would allow a senior police officer to apply to a judge for an examination order in a business context on reasonable grounds where there is reason to believe that an offence punishable by more than 5 years' imprisonment has been committed. And that's similar to the SFO right in serious fraud cases, so that police could then question a person and require answers. It is arguable whether even the SFO should have such a right, even with judicial overview, but it is a serious step to extend this to the police. But clauses 33 and 34 extend the police powers even further to any non-business case which, quote, involves serious or complex fraud that is punishable by imprisonment for a term of 7 years or more, or, quote, an organised criminal group, as defined in the Crimes Act. This opens up a wide area for police for use of compulsory examination and should be opposed for that reason. It goes too far and fails to achieve the desired balance between the need for police powers to fight serious crime and the need to protect personal rights and freedoms. It is easy to lose those rights incrementally in these ways. The line may have already been crossed with the SFO having compulsory examination rights, but at least the SFO is specialised. The police are not. There are requirements in the bill for reporting, but they are not likely to be effective, and we're likely to get onto a slippery slope so that the use of these powers become routine. Nor is the fact that the police would have to apply to a judge for an order a sufficient limitation either. Another area of concern is the power to be granted to enforcement officers for production orders. This is okay as far as it applies to a requirement by police for a person to produce a document in the same circumstances that apply to search warrants. If the circumstances are sufficient for a search warrant, then they should be sufficient also for the production of a document. But one concern arises in cases involving telecommunications network operators who would be able to obtain call-associated data as well as the content of the message or document itself, if it is stored in the normal course of business. Clauses 69 and 70 provide for an enforcement officer having the right to apply for a search warrant, to apply for a production order, and an enforcement officer is one listed in the schedule to the bill. And the concern there, of course, is that there are a lot of those agencies referred to in the schedule to the bill, and more may be added by order in council. So you have to ask the question, when will it stop? How many people ultimately will get those sorts of powers? It really just goes way too far. And the freedom of the press is also an issue. Now, Clause 130 recognises privilege for many groups of people, and the rights of journalists are protected amongst them, but there is
I'm sorry to interrupt the
protection-
honourable member. His time has expired. I call Simon Bridges.
Mr. Speaker, it was a